You all just. Oh, switch this along.
It's a me. Yeah. Access laws of the states are obviously.
You good?
Marion. Maybe as they.
I just assumed. Was like.
Yes. That's.
I am.
Also, you say that. Yes.
Like you're.
I am.
The word. Really.
I see the building.
Yeah, I do.
I saw you. I saw you there.
Yeah, it was there.
If it's
Yeah.
an arm, it's like.
Oh, September.
I've been there since last.
Sorry.
I. Oh,
Okay, sounds good.
Building.
So.
I think I was going in the elevator one day. I saw you and I was gonna say, hey, like.
I walk like I'm on,
No, me too.
I say Toronto did it to me. My mom gets mad when I get in the city. She's like, you're walking so good. I said, no, too.
Yeah.
Dude, I don't want to get like pushed out.
What? Just
Making a more change tires on our car.
No, maybe.
I didn't.
He's like, oh.
Am I on?
You're on the hook.
I'm on. I'm off the hook.
I don't think.
I don't like to speak without hearing something.
At least charged him good value rent. Other than living here, very difficult to speak.
I don't know.
Job.
I do too. Like, she was like.
Well, I may not have.
Yeah.
I probably had a road speed, probably had my stump speed. They really didn't let me out, you know, and I'm not on my name.
That's we get swimmers. Yeah, you know, if you have a very. Oh, no worries. Oh, sorry.
On is.
Or like a bad interaction with
You don't go like.
management.
So are you talking about?
Manager. Yeah.
Yeah. It's got too much work.
Well, I feel like I was.
He's really.
Okay.
He's enjoying it. Getting any feedback?
No, we. Small call. My name is Marion Sandilands, and I am a partner at Conway Litigation, which is the same Conway as the Conway Professionalism Speaking Series. And in fact, Tom Conway is here in the room with us. It is my great pleasure to kick off the event today by introducing our main event, Jacqueline Horvat, the treasurer of Ontario. Ms. Horvat was elected as treasurer by the Law Society last year in June 2023. She's a graduate of Windsor Law School, but we won't hold that against her. For those of you who don't know, the treasurer is the top elected official of the Law Society. So this is the sort of highest elected office one can be in the Law Society. And she is in fact the 6th woman treasurer in the 225-year history of the Law Society. She was first elected as a bencher in 2011. So a bencher, for those of you who don't know, is sort of the board of directors of the Law Society, and the treasurer is the sort of chair of that board. Ms. Horvat is a litigation lawyer, and she's the founding partner of Spark Law, which is a full-service firm which provides her with a close-up view of the issues and daily worries faced by the sole and small practice lawyers across the province. Ms. Horvat also has a broad and varied commercial litigation practice, representing both plaintiffs and defendants. She has appeared at all levels of court in Ontario, the federal court, and the Federal Court of Appeal. And so with that said, and with no further ado, it is my great pleasure to welcome Jacqueline Horvat.
Good afternoon, everyone. First, I want to thank you for inviting me today. I'm really pleased to be here. My favorite thing is to speak to students. I know we have lawyers joining us on Zoom, and we have some in the room as well, but I really enjoy speaking to students the most. So you've asked me to speak with you today about some of the contemporary regulatory issues facing the legal professions. And these are issues that are mutually important to everyone in the room. For you as students embarking on your careers at such a pivotal, challenging time in history, for lawyers like me practicing law, for academics, and for the Law Society as the regulator of Ontario's lawyers and paralegals. And as we think about these modern regulatory issues such as mental health and well-being, equity, diversity and inclusion, and technology, we must remember that as legal professionals, we have the opportunity to make a difference in the lives of the public that we serve. And we must consider these issues with optimism about what the future holds. So to the students here, as soon to be new members of the legal profession, you have a lot to offer. And that alone is reason for optimism. To the issues at hand, you bring a deep awareness of self and the importance of caring for all aspects of your well-being. You bring your own unique and diverse perspectives and lived experiences. And you come equipped with sharp skills and fluent understanding and familiarity with technology. And that sets you apart from those who have come before you. So before we get into some of the specifics of these areas, I'd like to provide you with some context about the Law Society, its governance structure, and its role as regulator. And I find that students, lawyers, academics need a regular reminder of what exactly the Law Society is and what it does. So the Law Society's mandate is to govern Ontario's lawyers and paralegals in the public interest by ensuring that the people of Ontario are served by lawyers who meet high standards of learning, competence, and professional conduct. The Law Society has a duty to protect the public interest, to maintain and advance the cause of justice and the rule of law, to facilitate access to justice for the people of Ontario, and to act in a timely, open, and efficient manner. So the Law Society was established in 1797. That's over 225 years ago. And it's one of the oldest professional regulatory bodies in North America. The Law Society's authority to regulate the practice of law by lawyers and the provision of legal services by paralegals is delegated from the Government of Ontario through the Law Society Act. So this means that the Law Society is independent of the government in regulating the professions. As lawyers and paralegals are the governors of the Law Society, this model of regulation is called self-regulation. In the self-regulation model, lawyers and paralegals, as members of a profession, are recognized as having a specialized knowledge required to regulate our professions. So as you heard, benchers are the directors of the Law Society's board. And the benchers are entrusted with the privilege of self-regulation in the public interest and to govern the organization's affairs. The Law Society has a very large board. There are 53 members of the board and 53 core voting members of the board. And in addition to that, we have other former ex officio treasurers who come to our meetings and guide us through the issues. So the 53 voting members of the board are made up of 40 elected lawyer benchers, 20 inside Toronto, 20 outside Toronto, and 5 elected paralegal benchers, and 8 appointed lay benchers or non-lawyer, Now, in convocation, which is what we call the board's monthly meeting, benchers make policy decisions for the regulation of the legal professions in Ontario and set the strategic direction of the Law Society. So the treasurer, that's me, is the Law Society's, as you heard, president and chair of the board. So each year in June, the benchers elect one board member to serve as treasurer. Now, I want to pause there to briefly tell you a little bit about me, my background, and what brought me here today. And I don't want to tell you that because I particularly enjoy talking about myself, although most lawyers do. But because I think it's important for all of you, students especially, to know where the leaders in the profession come from. And we all have different stories. Everybody in this room has a different story. So for the students, despite what you'll hear at certain stages of your law school education, particularly during OCI time, there is no longer one path to success. You should all strive to be the lawyer that you want to be, and not that somebody tells you to be. So I did not, as a little girl, want to be the treasurer of the Law Society. I didn't even want to be a lawyer as a little girl. And I didn't even know any lawyers until I went to law school. So I'm a first-generation Canadian. Both my parents are immigrants. At home, we still don't speak English. I was born and raised in middle-class, blue-collar Windsor, Ontario. And I worked throughout high school, throughout university, and law school as a cashier in a grocery store. Now, I don't have an undergrad. I went to do a math degree because I was really good at math and I didn't have to work that hard. And I quickly realized I didn't want to do math for my entire life. And law school just seemed like the next thing for me to do. So I wrote the LSAT, I did really well, got into law school. And then I articled 20 years ago now, I articled at an intellectual property law firm in Toronto. And the reason I did that was because I was told in law school, well, with your math background, you have to practice intellectual property law. So that's why I articled there. I very quickly realized that no, I don't want to practice intellectual property law I really had a great time during my articling working on a trial. And I realized that actually what I wanted to do was litigation. I also discovered I didn't want to work on Bay Street. It just wasn't for me. So I moved back to Windsor. I joined a small litigation boutique, a mid-size for Windsor, and practiced there for 13, 14 years. Now, during that time, when I was a 9th year call, 2011, one of my mentors there was frustrated. He's a former treasurer, and he was frustrated with what was happening at Convocation. So he said to me, women are underrepresented on this board, as are young people. Like, you're going to run for bencher. My reaction was, what's a bencher? So within 2 days, we got my nomination together and I was running. About 7 years ago, just getting back to my career path, I decided that it was time to move on from my firm. I left on good terms. Best advice is leave wherever you're leaving on good terms, because you never know when you'll need those people. And I started my own small firm with 2 partners. It was just the 3 of us for a number of years. Now, starting my own small firm from scratch, especially coming from a place where everything was done for me, was incredibly eye-opening. And that is actually when I realized just how many resources the Law Society actually offers its licensees. And they offer those resources to make their lives easier and to keep them out of trouble. And I'll highlight some of those a little later in my talk. So then, as you heard, this past June, I was elected as the 6th female treasurer in 225 years. And this was the first time that the role passed from a woman to a woman. So we hope to see that again down the road. Now, I tell you all of this because I want you all to be open to growth and to change and to evolving throughout your career. And that goes for the students in the room, that goes for you, those of you who've been practicing for 10, 20, 40 years, 50 years. Everybody, I hope for you that you're open to change and to learning from your experiences. So each of you, please embrace the experiences that brought you here today and that made you the person, the student, the lawyer, the academic that you are. And ask those around you about their experiences and learn from those as well. And know that there is, again, thankfully for me, no longer one path to success in this profession. So getting back to the structure of the Law Society, benchers, the directors, are supported in the governance role by experienced and knowledgeable members of the Law Society's management team. We have one with us today, led by the CEO. As some of you know, we are currently in the throes of a bencher election, which occurs every 4 years. The nomination period closed in February, and voting will take place for 2 weeks, beginning on April 19th. And the results will be announced in May. So for both students, once you gain your license, and all the licensees joining us, I cannot stress enough the importance of voting and participating in the election of your governors. Now, benchers bring to the Law Society their own professional and personal experiences that inform their views, perspectives, and contributions that they make to the governance of the Law Society. And this is why the Law Society's governors should reflect the professions that it regulates and the people of Ontario whose interests the Law Society protects. Having benchers with varied personal and professional backgrounds is an important aspect of a modern regulator. In my view, we must strive to ensure that important policy decisions affecting both the public and the professions incorporate unique and diverse views that will undoubtedly enrich the decision-making process. Now, the Law Society also operates an independent Law Society tribunal. The tribunal is established under the Law Society Act to adjudicate applications to the conduct, capacity, or competence of licensees. And the tribunal also hears applications for licensing based on the good character requirement. So an independent chair is appointed by convocation to run the tribunal, and the tribunal is separate from the Law Society. But convocation also appoints the tribunal's adjudicators, who include the benchers that you all elect. They also include non-bencher licensees and lay people from the public. And those lay people are appointed by the Attorney General. The Law Society tribunal's function is a key component of self-regulation in the public interest. Other organizations, such as the Ontario Bar Association and the Ontario Paralegal Association, advocate for the interests of the professions. The Law Society as regulator is different. The cornerstone of self-regulation is regulation in the public interest, not necessarily in the profession's interest. While the Law Society is ultimately the regulator of lawyers and paralegals, it also, as I said, offers extensive supports to advance the professions, to ensure high standards of learning, competence, and professional conduct, and to help keep lawyers and paralegals out of the discipline process. So before I highlight those resources, let me speak a bit more about some of the contemporary regulatory issues facing the professions. And the first is mental well-being. As legal professionals, our work can pose real challenges for our mental health. The very practice of law is demanding, long hours, complex work, heavy caseloads, high expectations that we all place on ourselves and those placed by others. Mental illness and addiction issues are present in significant numbers within the general Canadian population. But there is increasing evidence suggesting that legal professionals are at an even higher risk than the general population of experiencing career and life challenges, as well as struggles with mental illness and addictions. Recent research shows us that legal professionals are almost twice as likely to experience mental health issues like anxiety, stress, depression, and addiction, as is the general population. So as a profession, we need to focus on mental illness through ongoing discussion and continued research, and by supporting those who are struggling. And in recent years, we've made much progress in that regard. Respected leaders, like former Chief Justice George Strathy, have shared their personal reflections on the topic, helping to reduce the stigma and raise awareness about the importance of mental well-being for us as individuals and collectively as members of the legal professions. In the spring of 2021, the Federation of Law Societies of Canada launched the National Wellbeing Study, the most comprehensive study on the mental health of legal professionals to be done in Canada. Phase 1 of this study was published in the fall, and the Phase 1 report provides a detailed analysis of health and wellness indicators, as well as the risk factors and the protective factors, which explain the presence of these health and wellness indicators among legal professionals. Now, the report includes 10 global recommendations and approximately 50 targeted measures. In Phase 2 of the report, the research team is currently looking for lawyers, paralegals, articling students, and law practice program students in Ontario to participate in confidential virtual interviews about mental health and wellness. Now, major life events can throw anyone off. In extreme circumstances, if a lawyer or a paralegal is unwell and not receiving adequate support or treatment, they may be unable to harness the skills to properly serve their clients, manage their practices, or perform their important function in the justice system. As a modern regulator, the Law Society recognizes that preserving, enhancing, and investing in personal health, particularly mental health, is critical to the success of any legal practice and protects and serves the public interest. A strong sense of connection to our work, our peers, and to our purpose is at the heart of our overall well-being. And as treasurer, I believe that mentorship is one of the most important pillars of our profession. And mentorship, as I explained earlier, has been the driving force behind my own career. The guidance I received from my mentors and the insights that I gleaned about myself from these relationships helped me develop the confidence to set goals that I may not have considered pursuing otherwise. And the mutual trust and respect that are born of mentorship can create strong connections that anchor you to what you value most. My own mentors are individuals who reflect my fundamental values, both in and outside of the professional realm. And the legal community is comprised of individuals with a broad range of experiences, expertise, and ideas. And many of them are eager to support and advise you. So I encourage you all to seek them out and take advantage of the many rich benefits that mentorship can offer. Don't be timid. I promise you, unlike me, most lawyers do like talking about themselves. So just ask what their background is, what their experience is, and you may find a connection. And if you feel isolated or you feel like you're not connecting with anybody, the Law Society offers the Coach and Advisor Network, and you just have to make a phone call and they'll connect you with somebody, and I'll give more details of that later. So as we work together to protect the public interest and advance access to justice for all Ontarians, each of you has a unique perspective and experience to bring to the table. Access to justice, a key component of our mandate as regulator, is, after all, about building a people-centered justice system, one that breaks down barriers and is based in the principles of equity, diversity, and inclusion, and is reflective of all members of our society. As the Law Society and the legal professions move forward, we must continue to work to ensure that our profession is anchored in these important principles. And it was heartening to see these principles in action with the recent appointment of Justice Michelle Abonsawin to the Supreme Court. With her appointment to the highest court in our judicial system, she represents many different and unique faces of the legal profession, of our communities, and most importantly, of the people we serve. And she brings additional voice, perspective, and inspiration as each of a legal professional, an academic, a teacher, a woman, a francophone, an Indigenous person, someone who comes from a small town, and also as a parent, a partner, and as an active community member. So maintaining our commitment to the principles of equity, diversity, and inclusion is an important contemporary regulatory issue, in my view, for the Law Society and for each of us as members of the legal professions. It's up to each of us to listen and learn and ensure that the diverse perspectives and rich stories of Indigenous people and all members of our society are woven into the fabric of our justice system and integrated into the cultures of our communities. While these principles are controversial to some, the fact that technology and the future of our profession are closely intertwined should not be. As law students, the technological change that swept through the justice sector over the past few years has left you well positioned to traverse the challenges that are still ahead. And as treasurer, a key priority of mine is technology and innovation in the legal professions. As members of the justice sector, not only do we need the appropriate tools, resources, and knowledge to confidently move ahead, but it is also incumbent upon us to ensure that technology serves to increase access to justice for all Ontarians and that no one is left behind. All parts of our society have been impacted by new technologies, and certainly the legal professions are no different. There are new technologies that licensees need to be aware of, regardless of their practice area. Whether it's appearing in court by video, closing a deal remotely, assembling documents using unique software, performing research, or managing your practice more efficiently, new technologies and new legal-specific technologies are being developed at a rapid pace. And it can be a challenge for licensees to keep up with these changes and incorporate them into their own practices, especially while running a busy practice. But at the same time, the reality is that the nature of legal services haven't fundamentally changed because of technology. Lawyers and paralegals are relied on and hired for their application of judgment and their human connection to their clients. The judgment is based on an understanding of legal processes, an ability to limit risks, the ability to remove emotion from decisions, and to understand the key legal principles at play. With increased technology, there is more information available, and there are more tools that licensees can use to inform their judgment, but this doesn't change the fundamental concept. The human connection is understanding what a client really wants. Sometimes it's helping them deal with an extremely emotional issue in a more objective manner. And oftentimes it's simply knowing your client and understanding their needs. In a province as rich and diverse as Ontario, this means understanding that diverse clients have diverse needs and concerns, and that to provide high-quality professional legal services, you as a lawyer or a paralegal need to take the steps to understand, represent, and accommodate that diversity. It's about understanding how your client's past, present, and values informs their desired outcome in a particular situation. Technology won't, at least in the foreseeable future, be able to provide that judgment or that human connection. And developing your ability to provide sound judgment and human connection will remain critical for new licensees and experienced licensees alike. And they are skills that you will need to keep fostering throughout your careers. And in many ways, they will not be taught in conventional classrooms. Rather, they will be taught through your own life experiences. So for all of those of you in the room today, the students and online, I encourage you to diversify your life experience as much as possible. Travel, take a non-law job in the summer. And let me pause there. As somebody who hires summer students, articling students, and associates, the first thing I look for in a resume is has this person had a public facing job? Have they been a waitress, a bartender, a waiter? They worked at a bank as a teller, a grocery store like me, in a shopping mall. You know, do they interact with the public? Do they know how to speak to a person? Do they know how to read a person? And do they know how to make sure that the person feels heard? For me, that's the most important skill for somebody that I want to hire at my firm. It's not what your grades were or where you summered. It's, can you make eye contact and talk to me when I'm interviewing? So that's just a tip for all of you. So while the roles that lawyers and paralegals play remains fundamentally the same, increased technology does create new issues for the regulator. So as part of their requirement to be technologically competent, lawyers and paralegals are expected to understand and use up-to-date technologies relevant to their practice. So in the real world, this presents challenges. And I'll give you two real-world examples. The first is cybersecurity. So licensees are required to keep confidential client information. And licensees often deal with extremely sensitive client issues. So issues pertaining to personal relationships, financial relationships, issues that affect minors. And licensees are required to take this responsibility extremely seriously. So typically, especially today, this information is stored electronically, protected by cybersecurity. But what is sufficient cybersecurity today? What is a lawyer or paralegal required to do if there's a cybersecurity breach? These aren't issues that lawyers or paralegals have significant training in. They are also not issues that are static. So sufficient cybersecurity this week might not be sufficient next week. So the Law Society provides resources to help guide licensees, but we don't set out specific requirements. We need to keep striving to find the right balance so that licensees can meet not only their professional obligations, but also the level that clients and the general public demand of a profession entrusted with this public-private information. Now, a second real-life example is client verification. So when we get a new client, we have to verify that they are who they say they are. And now today, there are many technology-driven client or identification verification tools. So licensees need to know whether for a new client, they need to use an ID verification technology, or can they continue to review a client's ID in their office the way that it's always been done? If they do use an ID verification tool, are they complying with their professional obligations, or do they need to do more? And if you just search Google, you'll find a ton of different ID verification tools that are now on the market. So if a licensee uses a verification tool, which one will ensure they are complying with their professional obligations? I believe we're going to keep seeing new types of these tools enter the market. So licensees will be continually challenged on when they can or when they need to incorporate new technologies into their practice areas. And as it always has, the Law Society needs to help licensees meet their professional obligations as these changes take shape and help the licensees stay out of trouble. So to do this, we will need to stay alive to a rapidly evolving technological landscape. But the Law Society can also play a role in encouraging innovation. There is a real access to justice issue in Ontario, and technology can be a significant part of the solution. At the same time, we have a statutory obligation to ensure that the public is protected while encouraging innovative development. So finding this balance is not an easy task. It's one that governments and regulators around the world are striving to do. Now, here in Ontario, we've embraced the sandbox principle. Through our sandbox, named the Access to Innovation, or A2I project, companies or individuals that leverage innovative technologies to provide services directly to the public can apply to operate in the sandbox. So these aren't tools that licensees, lawyers, paralegals use in their practices, although they can, but these are tools that are client facing. So there's no lawyer or paralegal in between the tool and the client. So this sandbox allows the development of new innovative technological services that might otherwise be prohibited by the Law Society Act as unauthorized practice. And at the same time, the Law Society is able to provide regulatory oversight of these companies through privacy requirements, insurance obligations, reporting requirements, or other obligations as they may become warranted. And the public benefits through these new technologies and through a robust oversight of these technologies. So the Law Society's first approved participant is called Willful, and it provides online wills addressing an issue that has been continuously highlighted, namely the fact that most Ontarians don't have an up-to-date will. And I expect we will learn many lessons from this project and from the participants in the project. And these lessons will help shape the future of the Law Society's regulations. And this is one way for the Law Society to stay current with evolving technological developments. Now, before I conclude my remarks, I promised I'd speak about some of the resources and programs that the Law Society offers to students, to licensing candidates, and to licensees. So as a modern regulator, we recognize that what is in the public interest may also be in the interest of the professions. And this means providing access to the tools and supports you need to enhance and maintain your professional competence as legal professionals. So I'll briefly highlight a few of those resources and begin with the ones that students and licensing candidates can take advantage of. So the first is the Bridge to Practice program. So this program is a series of 34 free on-demand modules to supplement your hands-on learning and to add to your knowledge as new licensees as you begin your career. So these are for individuals who have studied law and are articling or completing their work placements, or for new lawyers to go back and refer to. The second is the Licensing and Accreditation's Navigating the Licensing Process video series. So you can view these videos on demand on your own time on the Law Society's YouTube channel. This series explains the licensing process, including applying, examinations, experiential learning and training, the good character requirement, and licensure. So there are 10 lawyer modules offered in both English and French. Next is examination tutoring. So the Law Society provides access to tutoring with experienced members of the profession to candidates who have been unsuccessful in a licensing exam. So candidates are eligible to receive up to 5 hours of free tutoring in up to 3 subjects for each licensing examination in which you're unsuccessful. Next is the Guide to Experiential Training, or GET. So this is an online resource and it's currently in development, but will be available later this year. So GET is a new series of online learning modules, videos, and resources to help experiential training candidates acclimate to the legal practice. The Law Society has also developed GET to help prepare supervisors and principals to orient their candidates using effective practice management practices. There are 4 GET stages, which are broken down into short 2 to 7 minute modules. This staged approach allows users to access the various modules as needed. So next is something that's offered to students, to licensing candidates, and to licensees, and that's the Member Assistance Program. So it's myassistplan.com. So MAP is a confidential service funded by and fully independent of the Law Society, and it provides secure web or telephone access to counseling, coaching, and to peer volunteers. So law and paralegal students, licensing candidates, and licensees, as I said, can get professional help with issues related to addictions, mental or physical health, work-life balance, career, family, and more. And additionally, MAP's Life Smart, Career Smart program offers career planning. So you should really take advantage of all of that. Next is the Wellbeing Resource Center. So this is a dedicated section of the Law Society's website that provides access to research, information, articles, and on-demand courses about mental health in the professions, and access to resources to help practitioners manage personal well-being. We also offer the Discrimination and Harassment Council. This is funded by the Law Society, but it's 100% independent and confidential. So its services are available free of charge to anyone who may have experienced discrimination or harassment by a lawyer, a paralegal, or a lawyer licensing candidate within Ontario. I mentioned earlier the Coach and Advisor Network. So this was launched in 2016 as a responsive way to foster collective competence and best practices in Ontario's lawyers and paralegals. So lawyers and paralegals are matched with volunteer coaches and advisors who are drawn from the professions. The coaches support the implementation of best practices in your practice, and the advisors will assist you with substantive and procedural law inquiries on client files. And there are confidentiality protections in place. Next is the Practice Management Helpline. The helpline answers questions about the rules of professional conduct and other professionalism and practice management topics, including paralegal scope of practice, client identification and verification obligations, and trust account and record keeping requirements. So the helpline is staffed by experienced representatives and counsel. And if your matter requires a higher level of input, they'll call you back and they'll give you the answer. So while this service is not anonymous, the helpline is a service for Ontario lawyers and paralegals that is strictly confidential from other divisions within the Law Society. So my firm has made use of this helpline many, many times. Next is the Technology Resource Center. So this is also a dedicated area of the Law Society's website. So it provides lawyers and paralegals with one-stop access to up-to-date resources, just-in-time practice supports, practical training and tutorials, and helpful continuing professional development programs. So these programs cover a wide range of topics, including what type of technology should your practice have, how to use various technologies, security and data protection, cybersecurity, cloud computing, and how to work remotely. We also have the Equity Legal Education Series. So this is a series of free equity legal education events that are held throughout the year. And the series focuses on the challenges and opportunities for equity-seeking communities in law and in the legal professions. So as I said, these events are free. but you have to register for them. And most of them qualify for CPD, continuing professional development, that you'll have to do once you're licensed for the students. And finally, I just want to mention Access to Justice Week. So this takes place every October, and it offers a full week of programming, including presentations and panel discussions about inclusive justice and community building. The events, again, are free, but registration is required, and most of them count towards your continuing professional development requirement. So I know I've missed some of the resources, so please, I urge you all to go on the Law Society's website, lso.ca, bookmark it, refer to it whenever you have an issue. And I think I'll stop there. So thank you again, everybody.
Sure. We do have some time for questions and answers. I can also look up at the questions and answers online if people want to submit questions there, but maybe we can start with the room if anybody has any questions for the treasurer.
Hi, thanks so much for coming to speak with us today.
Thank you.
My name is Risha. So I thought the mental health and well-being is super important. I found, or it seems as though the resource that LSO offers is very like for the individual. And I was wondering if now or in the future, possibly for the actual like law firms themselves, is there any pressure or requirement for them to, I guess, encourage mental health and well-being? Because it's great to be able to reach out to someone individually, but when you're in the workspace and got quotas to meet, like how are law firms being encouraged to support that program?
That's a really good question. We can't force a law firm, right, to recognize and support mental health and well-being. I feel that there is sort of a shift though in the profession. People are moving in that direction and being more responsive and supportive to people that are struggling. But here's what I'll say. I know it's difficult, but people who are struggling, nobody can read your mind, right? So it helps if you seek out the help yourself. That's one thing I tell people who I know are struggling, that they have to reach out for the help themselves. But I agree, like firms should be working in this space. Certainly amongst the smaller firms who we speak with regularly, everybody's shifting in that direction. We don't know what's happening at the big firms. Does Tom maybe want to weigh in if you're a bigger firm?
I'm not a big firm. 15, we're 15, we're a huge firm.
Bigger firm than mine.
It's just good business, isn't it? It's very good business. All we do is we organize bright minds with experience and training, and you got to keep them healthy. And mental health, you have to keep them healthy.
When I say like speak up, so I get applications all the time from people looking for a job, and in their application they say, I would prefer to work Monday to Friday, 9 to 5. And we respect that. We don't, I say be upfront about it. If you ask for it, eventually the culture will shift. I truly believe that.
Thank you. I see another question in the room, Stephen.
For various reasons, people have suggested that self-regulation of the profession could be threatened. For different people offer different reasons. What are your views on whether you think there is a threat to self-regulation in the province?
I think there's always a threat to self-regulation. I think we're the last standing jurisdiction. Well, Canada is the last sort of standing jurisdiction that still has self-regulation. It was lost in the US, it was lost in the UK. So I think there's always a threat to it, and we should always be mindful of it.
Building on that, what are the reasons you give as someone at the head of a self-regulatory body as to why that's an important thing from the perspective of the Law Society? And what are some of the advantages maybe?
So we are experts in what we do, right? And we should be governing and regulating each other. That to me is the importance of it. You don't want somebody from the province coming in and taking over the place. Your fees would skyrocket. People think that your fees might go down. Actually, they'd skyrocket. In the US, the courts regulate licensees. So it's not it's not the Michigan Bar Association or the New York Bar Association or the ABA. The courts regulate licensees. And a lot of those judges are elected officials. So, I mean, that concerns me for sure. So I think we should always be mindful of protecting self-regulation.
Yeah, so I'm kind of in that vein of self-regulation. So you said that self-regulation means that you work towards the public interest and not necessarily the profession's interest. Kind of just like speaking about, you know, advantages, disadvantages, of regulation. How would you define like the public interest, the treasurer, and maybe that's something that fluctuates with time and even within different groups, like we're talking about big firms versus small firms. So like, what do you see as the public interest generally?
That's a good question.
I know that's a very different question, but
It's a static, it's a moving target. I think it changes with what's happening in the environment. Sometimes, I mean, most of the time or often, the interests of the professions and the public do align and are on the same course. But occasionally, you know, they go off course, and that's when the governors of the board have to remind themselves that their fiduciary duty is to the public, not to those people who elected them. And there's the problem with our system, right? We're elected by other lawyers. So your natural sort of inclination is to do what the lawyers want, not what's in the public's interest. And when I mean, that issue, I would say arises only a couple of times, you know, throughout a year. Where you have a true conflict and, oh, well, I have to remind myself that I should be making a decision in the public interest, not in what's in the best interest of the profession, and those two don't align. So you asked me to define, so it's a mood.
you don't have to.
I'll get back to you.
Write a paper.
Questions behind Tom. Yeah.
Thank you. I really enjoyed the part where we were speaking about cybersecurity and all those initiatives like the Willful project. I wanted to ask you, has Law Society considered, or has it been something that's explored like on the blockchain? Because that's something that's very confidential, immutable. Obviously has its dark sides, but I want to know what you thought about that, because it's something that's trending now, but the technology is there.
Yeah, so we had a technology task force that resulted in the Access to Innovation sandbox being put into place. So that task force looked at things like blockchain and other ideas. For a time, it was popular, or I shouldn't say popular. For a time, people thought that maybe trust accounts could move onto the blockchain, but nobody really understood what that meant. So I thought, oh, maybe that's not a good idea. And I think I get the sense that everybody's sort of waiting for every other jurisdiction to move in that direction. And nobody wants to be the first, because it is a bit scary. It's sort of the unknown. So yes, we have considered it, but we're just waiting to see what happens.
There's a few reports from the technology task force.
They're all
So,
on the website.
yeah, so if you Google it, you can see some of the assessments and stuff.
That's right, yeah.
Good question there.
Just going back to the question about presidential elections and that stuff. I think I read an article recently how slates are becoming much more prevalent in these elections. Just wonder if you wanted to share any particular thoughts about the pros or cons.
So I'd rather not talk about this because I am running again, so I'm uncomfortable.
Okay, yeah.
Yeah. Have a private chat about it later.
Well, again, maybe since we're on hot button issues, maybe I want to ask you about defining the blockchain or public interest, but I know sometimes we have the treasurer, and one question students have, you know, they're finishing their law degree, spend a lot of tuition, look at licensing fees, they also look at fees for, you know, lawyers, and maybe you can give a sense about, you know, what that money goes to, not a breakdown necessarily of the budget,
Sure.
but, you know, it is a significant amount of outlay for people that maybe don't have a firm covering it. And I think it's good for people to understand why that money is being charged to them.
So your licensing fees, once you enter the licensing process, I think they're around $5,000.
$5,344. I got it last week.
For some people who just pay them.
Or just about to be.
So it's all self-recovery. We don't, like, first of all, we aren't making a profit off of your fees. It's entirely to pay for the licensing process. and everybody in this room and every other candidate out there. They are higher. So when I was licensed in 2002, I had to think for a minute, my fees were about the same. But back then we didn't have a law practice program that was funded by the candidates. So I'm actually not sure what my licensing fees paid for, but they would be higher than they are now. Not that I'm trying to justify them, because they are high, but it's fully recovered. But your licensing, your
Sorry, I'm saying that-
license fees.
Right, that licensed.
Your license fees, once you become a lawyer, those cover all those programs I talked about, plus all the other programs I didn't mention. They cover the discipline process, so investigating, what, Tom?
I was just saying, we also have probably one of the most historic buildings in the
Oh,
country.
well, we'll get to that in a minute. But they also cover, so when a student gets into trouble, there's an investigation, there's discipline counsel. There's a lot of time and money that's spent investigating those complaints. So your fees, again, where nobody's making a profit off those license fees, it goes to pay for all that. And all these programs that are offered to keep people out of the discipline process, right? That's why we have all those programs. So we're hoping to catch people before they get in the discipline process.
Is there another question?
Yeah, I had a question about technology. You mentioned willful, like leveraging that to improve access to doing wills.
Yeah.
And I'm wondering, like, is the Law Society like looking to or have any other technology on the radar right now to improve access to justice? Like, I find it's a really interesting topic and just wondering if there's more to it.
Well, keep an eye on the website, because what happens is these technologies come in and they apply to play in the sandbox, essentially. They have to meet a bunch of criteria, including being for access to justice or promoting access to justice. They have to have insurance coverage, all these other requirements. So you'll see more people added. Willful was the first, but there are others in the application process. So keep an eye, you'll see them being added. And it's a pilot project. So it's a 5-year project. At the end of the 5 years, we're hoping that we have enough data from the technologies that we're playing in the sandbox to collect from them to make an evidence-based decision as to whether the Law Society should be regulating technology or only human beings. That's really why we did it.
So you're kind of producing the system, the framework, and then letting companies come and apply, and then.
So willful could arguably be accused of unauthorized practice. So they don't have a license, right? They might have a lawyer on staff or a paralegal on staff. Or they might have a lawyer on staff. Paralegals can't do wills, I don't think. So we're giving them a free pass to sort of try out the Ontario market for a limited period of time. They have to report back to us. They have to give us data as to how it's going, what were the problems and things like that. So that's what we want to learn from.
Oh, thank you.
Maybe going off of that, are there any competency requirements for lawyers to be able to like use new technologies, especially when thinking about? Just thinking about.
The treasurer mentioned, so since 2019, nationally, our federal model code was modified to include a duty of technological competence. And now that I think as of, was it 2021, it was adopted into the Law Society's code, or was it just this fall?
I don't remember.
The time of the pandemic strange. So now Ontario lawyers have a duty of tech competency. The Law Society has, I think, as the treasurer noted, defined it quite broadly. It says you need to be able to use and understand relevant technology. With the idea that what, a criminal defense lawyer in a solo practice is going to use versus an IP lawyer is going to be different. And so I think we're now starting to see more interest in kind of being more specific and helping different practice areas develop. I don't know if we would add anything to that.
Well, arguably, we always had a duty of technological competence because we all always had to be competent, right? But I will tell you, I have counsel on the other side of files who don't have email or don't read their own email. They want me to email their law clerk. Their law clerk then prints it out and it delays things. So, that's not promoting access to justice if you're not learning to use email.
Did that answer your question, or do you want to?
Yeah, it does.
Okay. You have a follow-up question? Or different question?
I have a question. Sure. Sorry, I want to hog. So you had said earlier, like there needs to be a cultural shift alongside like the education that you guys provide to have firms and lawyers be more mindful of things like mental health and diversity and things like that. But I feel like a lot of that cultural shift could start in law school itself, just because like law school, I think you could argue like perpetuates that mindset of like working law and competitiveness and things like that. And you had mentioned like the OCI process, for instance. But I know it's like the LSO that kind of sets the rules of the OCI and like basically like how intense it is. So I was just wondering if you could like speak to that and kind of just things that you could maybe see changing in law school itself, even though I don't know how much jurisdiction like.
Well, I'm the chair of the National Requirement Review with that. I was on the committee, and Tom's a past chair of that committee. So that sets basically the boxes that law schools have to be a qualified law degree. But no, I think there needs to be a culture shift at every level in society, you know, law schools, high school, university, firms. I think the culture shift for the firms it has to start at the top down. So somebody like the Chief Justice, former Chief Justice Straffy, coming out with an article talking about and talking publicly about his struggles with mental health. Like that shook the bar. I mean, people paid attention. And then there are other lawyers who have done the same. They've written and they speak on their own struggles. So it's more about normalizing it. Like it's not something you have to run in the corner and hide about and not talk to anybody. It's promoting that, like we are supportive, you know, we are a supportive mentoring profession. So I hope it's a culture shift at every level.
One thing I'm kind of interested in is the mental health and addiction side of things. And a thought that I had is I think a lot of people, when they, for a certain period of time while they're addicts, can remain addicts and be happy to be addicts for a while. They're not going to necessarily seek for help until things become so bad that they are forced to see that it's problematic. But I'm kind of curious, and I don't know if you know, like, is there a way that the Law Society is going about trying to unearth issues of addiction where an addicted lawyer is happy to be an addicted lawyer for the next 10 years?
I mean, eventually, I would guess that they would end up in a discipline process, right?
Okay,
So that's where it becomes.
but there's no way you can really sleuth around and
Yeah, I mean, we do spot audits and things like that, but it's not to go into a firm to make sure maybe we should be doing that. Maybe we should be going into making sure to check to make sure the culture's, you know, a happy one. I don't know. I would say that we don't have the resources to do that. But I mean, there is the members assistance program, and I try to promote that every chance I get because I encourage people, you know, it's confidential, you can call. But it's about making the person admit they have a problem, and I'm not sure how we do that, right?
Could I just add something? The issue for the Law Society, at least one of the issues, because we revamped the program when I was there, and one of the things we have to remember is that if you're a lawyer and you have an addiction or a mental health issue and you want to access the service, right? You want to have the assurance that what you're going to be doing is going to be confidential and that it's not going to leak over necessarily to, let's say, the discipline department where they might have a different view of your problem. So that's always been so I think it's worth emphasizing that there is a hard line between the lawyer assistance program and what happens and the information. There's an information barrier between that program and what goes over the Law Society. That's what
It's completely separate, no impact.
I said, I've had a few lawsuits and been really happy. Not every service is going to work for everybody. And I always encourage people to try out different things, but law students have spoken very favorably about it to me, having used it in law school.
Good to know.
Yeah.
Yeah, I just wanted to make a plug again for the National Wellness Study. And I'm happy so I work at the Federation of Law Societies, and I'm a former UOttawa grad, so glad to be back here. But I'm happy to share some links with Professor Salazan, because the study is really comprehensive and looks not only at what law societies do, but also what law schools can do and what law firms can do to address the issues that we found through the study, but also to do that culture shift. So there's a lot in there, I think, for everyone to dig into. So I would really commend that reading to you. So I think I think it's gonna be part of that culture.
I saw your hand.
Yeah, the question relates to all this discussion
Oh,
of
great.
mental health.
Okay.
So I think what you mentioned about changes being top down, a lot of it might involve sharing their experiences. But the question is, do you think there's a balance to be struck where people are speaking out and maybe they don't right now is because of their questions of their competency coming up? Because more and more people are saying this is their challenges, maybe the public will view it as maybe lawyers aren't competent anymore, they have still things going on. And kind of how do you, yes, balance wanting to create a culture shift, but at the same time, making sure people are competent, even though they could have these personal challenges and, still be successful lawyers.
Yeah, no, I know of big firms, for example, that have intervened, had sort of, come to Jesus moment with a senior partner who was struggling with all sorts of things. So they intervene themselves. The Law Society, I think, and I hope, aims more of their services towards the smaller and sole firms because that's where people are most isolated and need help. But you're right, if people are out there speaking out about their struggles, yeah, it may create eventually a discipline problem for them, but we operate on a complaints-based system, so somebody has to be about it and it's investigated and then it goes through the system. So sure, maybe that's why more people aren't speaking out about it. But a number of people have. You can also create a safe space within your own firm, right? You should be creating a safe space. Everybody should be creating a space safe in their own home.
I just speaking so much about firm culture and the importance of mentorship. It's obvious that you really need to be in a firm that has similar values to you and mentors you in a way that you find effective. How do you, as a student and then as a junior lawyer who may be looking to switch firms, how do you really uncover a firm's like true personality? Because everybody always puts their best faces into the interviews. They put, everything on their website is always perfect. And there's very few resources to actually be able to go in and be like, is it really as good as it sounds? And then also, how do you balance that with the pressure of getting employed after being unemployed for 3 years and, taking on student debt and having all the pressures that are associated with graduating? At what point do you say like any job is a job, even if it's not the right one?
So on your first question, how to find out what the firm culture is actually like, I mean, the best advice is to just cold call or the junior associates and invite them for a coffee or lunch. Like people are so responsive, right? I get random people emailing me all the time. I always respond. I never leave anybody hanging and I make the time to meet with people. Everybody that I've encountered in our profession is the same way. So reach out to those people and ask them. I mean, that's the best way to find out. On your second question, I mean, listen, I didn't have to deal with the debt, right? When I went to law school 20 years ago, it was $2,000.
Just to add to that, I think another great reference for finding out about the culture of a firm are people who used to work there.
Oh, that's a good point.
So if you go on LinkedIn, especially alumni, right? Alumni people, you have a network, people be generous. If somebody has a negative experience, like you should think about that, but you may discount that for various reasons. But if somebody had a positive experience, then there's probably less reason to discount that. So talking to people who worked at a place of employment that you're interested in, I think is a really good source.
And people leave for all kinds of reasons. I didn't leave my firm because it was a terrible place to work. I left because it was just time to move on. It was time to do something new.
On the same note of speaking to people that work at firms during the OCI process, when I was shopping around as well, I would talk to students, the articling students, and I had a really good experience with one. With the student that I spoke to at the firm that I summered at, she told me a story because I was talking about like, what's the work environment like? And she said that she had a case that she was working on, but it was really sensitive for her and like she couldn't handle it. It was something like with kids and sickness and it wasn't a good case for her. And she said she reached out to the attorney on file saying, you know, like they asked her how was she doing? She was open. Like, I'm having a really hard time with this file. It's a lot for me, like mentally I can't handle it. And they said, that's totally fine. Like you should work on things. There's so much diversity here. You should work on things that you're happy with working on. And so she was taken off the file. And of course you're thinking, oh my God, like I'm thinking, oh my God, she complained. Like, you're not gonna get hired back. She's hired back. Even though she expressed, so my go-to through life experience, but also like from what she's told me, which gave me a positive view, is that like, if I'm really uncomfortable in a situation, I'm not going to partake in it. And I think that we should probably travel along the lines where we're comfortable in expressing, I don't really care, I don't really care. This experience is not like a good one for me. And how they respond to you is really important. So she was articling at the time, she was taken off the file and now she's back as an associate. So it didn't work against her.
I know, I think we have to go in a minute, but I just want to say, you're all going to be students or are summer students, right? Some of you. Ask whoever your mentor is or whoever you're assigned to work most closely with, ask them to schedule a weekly check-in with you. So that's what we do with our students and our associates. Every Wednesday morning at 9:30, we get on the phone or on a Zoom or in person, wherever everybody is. And it's just a check-in. I mean, it might be 5 minutes, it might be 2 hours, depending on what's happening. But, you know, I can't read their minds. So I make a point of asking them, like, are you okay? Are you too busy? What's going on? So the people that are sort of the leaders of the firms they have to take the initiative and do that. Or you can ask for that check-in. Just say, I'd like to set this time aside. And, like I said, it might be 5 minutes, it might be half an hour, but I'd like to know that I can speak to you at least once a week to catch up on all the questions I have. It's like, I'm terrible at email. It takes me weeks to respond sometimes and our poor students, but I pick up the phone and I call them because I know they're agonizing. But you'll find like people are not always responsive when you're in a trial or like Tom's doing trials left and right. It's hard to keep up with your emails. So it's good to have that time always set aside each week. Know that you have it with whoever you're working with.
Well, that's a wonderful, so much covered, and thanks for.
Make sure to take more food.
Class. Go far. Tom Hanks is my other.
Yeah.
Selling me a person. I'm like, wow, I didn't know we were getting some. More examples later.
Good. Obviously. I heard you guys want.
Yeah, I've been.